pursuant to Rhode Island General Laws 42-46-5, subsection A, subsection 2, to discuss and/or vote on litigation pending in Providence County Superior Court, captioned HSBC Bank, USA, NAAFT, Wells Fargo Asset Securities Corporation, Mortgage ABPTC versus Gail LaFond and Daniel Gritch and Nancy Gritch and the State Board of Elections, PM 2003-02636. Do we have a motion to go into executive session?
So moved.
Second.
Moved and seconded. All in favor signify by saying aye.
Aye.
We will go into executive session.
Oh, good, all right, thank you. So, how are you? Yeah. No, not yet. No, so it's not, we always had it, but we don't always get to it. It's on. So, oh, yeah, that, I don't know about. So, where is it? No, I heard something, but someone who downloaded it. Yeah, yeah, and, I don't know, some people that take a lot. Some people that yeah, yeah, it's fun. That's a good. Yeah. Eight last year, yeah. Yeah. But you don't. No, so all this stuff, right? I'll play. We tried to use YouTube for that, for recording, and without restriction. But Zoom has this. Yeah, it was, so it would, you have to have the couch. Way around the
Do I have a motion to resume and seal the minutes of executive session?
So moved.
Second.
Moved and seconded, all in favor signify by saying aye.
Aye.
Aye. At this time, do I have a motion to move agenda number 9 up on the agenda to be heard now?
So moved.
Second.
Moved and seconded, all in favor signify by saying aye.
Aye.
Any opposed? The ayes have it. The board will now hear agenda number 9. The board may discuss and vote to reduce the accrued fines against Daniel J. Gritch pursuant to the board's reduction of penalties and suspension of campaign finance account regulations. And counsel, I'm going to turn to you at this time to start us off.
And we could have the people here on this matter identify themselves.
Can you
Just have
help
to-
them?
Jacob, can you get their mic?
Thank you. No help you, Irina.
John D. Simone, attorney for Daniel Rich.
And Rick will probably need you up here as well. Madam Chair, members of the board, the process here, and this will be our first time applying this new regulation, would be to assess and make a determination of any reduction in the campaign finance fines that have been imposed against Mr. Grish over the years under our statutory scheme of Title 17, Chapter 25. In that process, you should hear from Rick, Mr. Thornton, on the formula that we have devised with respect to reducing outstanding campaign finance fines. And Rick, perhaps you could now give us that information. After we have that discussion, then we could hear from the actual filer and his attorney. So Rick, why don't you start us?
Okay, good afternoon. The original fines assessed to Daniel Gritch as a candidate for public office over multiple campaigns totaled $71,754. As legal counsel indicated, that was provided per the statute. A newly adopted regulation has been utilized to reduce that amount, given the fact that the amount is deemed to be disproportionate to the violations. And the new regulation calls for a reduction to the amount of $28,169. The regulation that was adopted used the formula which fits Mr. Gritch's situation, wherein he registered as a candidate for public office, filed a declaration of candidacy, and qualified for placement on the ballot, and filed all campaign finance reports due within an election cycle, including a final accounting to dissolve his campaign account. Meeting those criteria, Gritch's fines, the board may vote to reduce any outstanding penalties to a maximum of $1,000 per report that was filed past its due date. Again, using that formula, the fines were reduced in total to $28,169. That amount is also deemed to be somewhat excessive, given the fact that if you look at the reports filed by Mr. Gritch during his campaigns, he, number one, self-funded his campaigns for a total of about $2,200 over 5 campaigns, and again, did no funding outside of his own money. There's a statutory provision that would allow the assessment of a fine of 3 times the amount.
Well, before you
Yes,
get into
yes.
that, Rick, just so that
Sure.
we have the numbers down, first, can you just, for the record, indicate how you came to the original amount of 71,000? What's the,
Certainly. The statutory language calls for any report that is not filed by its due date is assessed a $25 fine automatically. A notice of non-compliance is sent to the candidate, apprising them they need to file the report. and end of the $25 fine. If the report is not filed in response to that first notice, a second notice is sent by certified mail. And then if the report is not filed in response to the second notice, there's a $2 per day fee that's added to $25 and continues to accrue at $2 per day until the report is filed. In Mr. Gritch's case, many of the reports for the 2006, 8, 10, and 12 campaigns for public office were not filed until the latter part of 2012. So in many cases, you had accruals of as much as five years at $2 per day per report that was due and owing. And that's how the total fine reached the level of $71,754.
And the violations go back to the campaign period of 2006?
2004, when he ran in 2004, there were some fines assessed back then. Those reports were filed in February 2005. So again, after the actual campaign, but not as late as the reports that followed for subsequent campaigns.
And we obtained a judgment back in 2013 to that effect in the amount of approximately $71,000?
That's correct.
Okay. And then with respect to the $28,000 figure, how did you arrive at that?
Again, there was a regulation that was recently adopted by the board. The purpose of that was to take any fine that has been assessed by the board that may be deemed disproportionate to the violation and reduce it to an amount that would then be proportionate and not violating the person's Eighth Amendment rights.
But the amount, was it based upon per filing that was due?
It was based on a per filing, setting a maximum of $1,000 per report.
And under the reg, does the board have the authority under the regulation to go below that amount?
Yes, the fine that is set is a maximum of $1,000 per report.
Okay. All right. And then how did you determine the amount that Mr. Grish actually spent on campaign finance activity over the years?
The amount that he spent was, the determination was by reviewing the campaign finance reports that were filed. Again, many of them filed in November 2012. Again, during those campaigns, the reports indicated the campaigns were self-funded, his own money, and did not collect any outside money.
Okay. So let me, and if I could now share with the board, the purpose for the regulation, as Rick said, was to make sure that whatever we do by way of a fine and penalty would be within proportion to the offense that occurred. And through no faults of the board, the way the statute is written, a lot of these daily amounts continue to accrue almost exponentially when you have someone who has been involved, had a requirement to do a filing, and just never did so, or did so in a delinquent fashion, and they go on and on and on. I don't believe that anybody on the board presently was here back when I first raised this issue with the board back in 2013. Frankly, it was for this very case that I observed that by applying the statute across the board, we were coming up with a figure for one filer, Mr. Grish, that seemed to be far in excess of the actual offense that occurred. And I did analyze that for the board under the Eighth Amendment. These many years later, the purpose for the regulation was to do just that. And this is our first time, our first rodeo applying the regulation. It's just been passed. So it's not working perfectly, because when you do a formula application, we're still in the range of about $27,000, $28,000 for someone who probably spent around $2,200, and I have every confidence that our staff has fully made that determination accurately. What I was thinking of and what is not in the regulation, but you certainly have the right to reduce the amount, is if you look at other parts of Chapter 25 of Title 17 of the general laws, and that is your primary statutory scheme for campaign finance enforcement, you'll see that under 1725-16, there is a process that the board has as an option to basically litigate in Superior Court violations of campaign finance laws. And when you look at the remedies that are available for the Superior Court, it states that in addition to the actual cost of the violation, the court is able to impose up to treble damages on that amount for the failures to file, the failures to report the amount, improperly using money, whatever that number is, the court looks at it after a hearing, after a trial, and says, if there's a violation, I can actually impose 3 times that amount. In my view, we should consider modifying the regulations so that we have a provision similar to that, so that we have like a safety valve within the regulatory scheme that allows us to always make sure we're within proportion. If it's good enough for the Superior Court for proportionate, I think it's good enough for us. Without that being in the reg, you still have that language that Rick mentioned, which is up to a maximum of $1,000 per filing offense, meaning that you can go below it. It seems to me that it would be appropriate to consider an amount in that range of 3 times the amount of the actual offense, which would be somewhere in the range of, and Rick can give us that number, it must be around the 6,000 range.
It's 6,600.
That would be my recommendation, Madam Chair. That would be my recommendation for Mr. Gritch. And my recommendation would be that we modify the regs so that everybody is always protected to that extent of a cap of 3 times the actual value of the offense. But with that being said, Mr. Gritch is here, Mr. DeSimone is here. Do you wish to make any other comments regarding that analysis or?
Yeah, so if I may, so am I to understand that you're recommending the board to reduce the fine from 28,000 to now 6,600?
That's going to be my recommendation.
That's your recommendation?
Yes.
Okay. Certainly, on behalf of Mr. Gritch, we appreciate that. I mean, anyone who's ever run for office would know that, unless you're sophisticated enough to look at the election laws and have someone help you and assist you with the treasurer and so forth to make all these filings, it could be very difficult. So I just wanted the board to know a little bit about Mr. Gritch, who I first met when he ran against me, he actually ran against me. So anyway, he didn't graduate high school. He got a high school equivalency some 4 or 5 years later. During the period of time when he was running for office, he was taking care of his sick father, who was sick for 12 years, and then his mother. But he had a burning desire to run for office. And as was mentioned, he ran, I had six times, but I guess it was said it was 5 times, but he ran for council. He ran 2004, 2006, 2008, 2010, 2012 for General Assembly. He ran against a rep and senator. But he never had a sophisticated campaign. I mean, as I recall, he had like a dump truck, and he put wooden signs on the truck and would just ride up and down Smith Street. I mean, that was the extent of his campaign. And, in my letter to you, I said that he spent less than $2,000. I had a conversation with Richard, and I thought Richard told me he spent $1,500, so I put $2,000. I guess it's actually $2,200. But he never received any donations from anybody. He spent his own money, and as you can see, over the course of 6 elections, they have it somewhere around 2,200. So I guess there's 4 reports for each election, and the way the penalties are, as Raymond said, it became a monstrous number, and certainly the amount of the number didn't meet what actually happened. And when I spoke to Dean, I said, did you know you had to file campaign reports? And he said, when I first started running, I called up someone from the Board of Elections, and they told me, if you're not raising any money, if you're not collecting any money, don't worry about it. So, that's pretty much what he did, and he just kept running. And I think 6,600 is a great number from where we were. I mean, taking into consideration, we have a person who had a great desire to run for office. He ran for office. He, wasn't sophisticated enough to follow the right procedures technically. But to find someone like Dan, $6,600 for someone who only spent $2,200 of his own money over the course of, looks like 15, 20 years. I think even that is kind of outrageous. And I looked at the law, I gotta say, I looked at it this morning, but I noticed under every penalty, the last sentence says, the Board of Elections shall have the authority to waive late filing fees for good cause shown. And even for the 2-day, it says, the Board of Elections shall have the authority to waive late fee filings for good cause shown. So, I mean, I guess it depends on how the board feels good cause is, right? I mean, here's a gentleman who, we should thank him for participating in the electoral process, right? He really had no campaign, he had no sophisticated operation. He didn't take money, not even from relatives. He just wanted to run for office. And as a result, he's sitting before you with well, now it looks like it may be a $6,600 debt, but it went up to $70,000. And what he did for a living, he was a carpenter that got jobs here and there, and that's how he survived. So frankly, the reason why we have boards like you is so you can look through some of this minutia and say, look, we should thank this guy for running all these years. He ran against me. I thank him for participating. I mean, he ran, he did his thing. And should we penalize him $6,600? I mean, he's very sick. He was in the hospital. He almost died. He took care of his father, his mother, and now he takes care of his sister. $6,600 is a lot of money to Dan Gritch. And while I'm sure you're going to say, well, he has to follow the rules and we have to set an example. I think maybe we should set an example with someone who spends $1 million a year campaigning and as a treasurer or runs a sophisticated campaign and has a college education. We shouldn't set an example on someone like Dan, who even after they sued him, went to court, he still didn't do anything about it. And I happened to have a conversation with him one day and I said, Dan, how much do you owe, by the way? He said, I think it's a lot of money. And I called up Richard, I found $70,000. I mean, every lawyer I talked to said that's obscene. But I would just, implore the board to use their sound judgment. Certainly, we would like the board to waive everything, but I guess that's not realistic in today's day. So you have to come up with some figure. I would suggest the original fee is $25. So the legislature, in their wisdom, directed you to fine someone $25 for filing late. I mean, and they said $2 a day for every day thereafter. I mean, think about it. I don't think the intent was ever for someone like Dan to come before you and spend $6,600 to do away with this. So I would ask the board to use their good conscience and say, look, what should we assess this at? He spent $2,200 over 6 elections of his own money, never took any campaign contributions from anybody, never did a mailing. I mean, if you look at some of his reports, he went to Staples and made copies of pamphlets. And I think on election day, he'd stand in the polls and hand out pamphlets. I mean, is that the type of person we really want to set an example of? So I would just ask the board, knowing what you know about this case, to set something more in line with what the legislature envisioned, which was a $25 fine and a $2 thereafter. Obviously, by the true letter of the law, it could add up to what it adds up to. And by your regs, you just changed it. So now it's $28,000. But I can tell you, I never envisioned it to be like this. So I would just ask the board to look at the case and, if anything, it should be less than what he spent. And he spent his own money. So with that, I really don't have anything to say. Dan is here to answer any questions that you might have. I'll answer whatever questions you have. But essentially, we're just asking for you to show recognized the hardship and what happened. It wasn't malicious, it wasn't intentional. It was just something that he was told not to worry about it. He believed in his heart he didn't have to worry about it because he never took any money from anybody. So with that, I have nothing else to say.
Thank you, Mr. DeSimone. Does the board have any questions for either Rick, Mr. DeSimone, or Mr. Grish?
I have a couple of questions. Mr. DeSimone, there's no rule or law for the unsophisticated person running for office and an old rule for the sophisticated person who's running for office. The rule applies to everyone. So what the board did, long before I became a member of this board, applied the statutory scheme to the outstanding violations. That was based upon what the General Assembly set forth. So it's not something that the board at that time created on its own. It followed the law at that time. And as I understand it, your client failed to respond. And Mr. Thornton sent out, I don't know how many letters. How many letters did he send out? Right, Rick?
The communications,
Yeah.
both certified and at least 75 written correspondence and phone calls.
Yeah, and he didn't respond, so can't say, hey, he's a simple person and should give him a pass. He just didn't bother to respond. He just blew everybody off. It became so bad that that the board back then authorized a suit against your client, and the judgment was entered. And even then, after the suit was brought, I think your client came before the board a couple of times to request relief. And we asked him to reach out to Mr. Thornton to see if they can work out an arrangement, something less than what the judgment was.
Mhm.
And he failed to respond then. Okay. Now, as I understand it, there is a suit brought by the bank, his bank, to foreclose on his property. Is that right?
That's correct.
Okay. So is there, and I understand that your client's been served,
Yes.
right? We've also been served because we're a lien holder.
Yes, that's
On
true. You
that,
would be
okay,
served.
you're right.
Yes.
To respond. So what is the status of that suit?
It's pending.
Okay. Is there a purchase and sale agreement pending also?
There is.
Okay.
There is.
So
Which is, go ahead. I
So,
don't-
yeah, when is the closing on that one? Closing
We don't
date?
have a closing schedule.
Sometime in June, perhaps?
There's none scheduled right
Okay.
now.
And what is the amount of the pending sale?
The amount of the pending sale is approximately 362, something like that.
Okay. And the outstanding mortgage would be how much? Balance?
I think it'd be 200 and something thousand dollars.
Yeah, about 230.
230?
Yeah.
Yep.
Okay, so it's roughly $130,000 equity.
Yeah.
On that
I'm
sale.
not sure what these questions have to do with the issue at hand.
Well, question
I
is,
understand
the question
where you're
was,
going, but
what
I'm
his
not
ability to pay was one of
Right.
the issues we asked him to address, which he never bothered to show up and speak to Mr. Thornton about. So I just wanted to get some facts before this board as to what the status is of his ability to pay the judgment. That's number one. And the second is, whether or not the board will reduce the fine. Our legal counsel has come across with a proposal which seems reasonable based upon the totality.
Yeah.
But to say to the board to waive everything and just fine them $25, it's, it doesn't make sense.
Yeah, so
Uh,
if I could just respond to that. I hope you didn't take me literally as $25. What I meant to confer to the board or suggest to the board that the actual penalty that the legislature set up was $25. Forgive me if I gave an implication that I thought that you should give them a $25 fine. I was just trying to draw a reference point between the fine, the original fine of $25 and the $6,600 that well, not the board, but the administration of the department is recommending to the board. So that was my intention. And, it should be noted that he doesn't own that house by himself. He owns it with two other people. So, That's why, I didn't ever talk about his ability to pay it back. I just talked about the righteousness of it, on the spirit of the law. For a person like Mr. Gritch, it really shouldn't matter, if he has a house that he's had for 100 years and now it's being foreclosed. That should show you the amount of distress that his life is in, right? The house is in disrepair. Houses in that neighborhood, that's the PC area where they have rentals, go for 500,000 all day long. But his house is in such disrepair, as is his physical health, that we're willing to take 362,000 for a sales price.
Is he living there? Is he living at that
His
house?
sisters live there. His sisters live,
So there are 3 names on that deed.
yes.
So what's the relationship to Mr. Gritch?
Well, first of all, I'm not sure that these questions are pertinent, but, and I don't know why you would be asking those questions, but we're here to talk about a fine. His sister, one of his sisters is on the deed, and Gail LaFont is on the deed.
I understand, but there's a lien on the property. If there was no lien on the property, we wouldn't be asking these questions.
I understand that.
Okay.
I understand that. I'm asking I would be asking the board to release the lien upon payment of whatever the board comes up with, obviously. But, Mr. Schultz, I'm sure you've been around a long time, and not everything is black and white, right? Not every fine, let's just calculate it and that's what it is. That's why you're here, right? So you could adjudicate these issues.
I want to come up something
Okay.
reasonable.
Yeah, and
also,
I think anywhere, first of all, I think the board at 6,600 from where we were is a great place to start. I didn't know what the figure was going to be before I sat down. Last time I talked to Richard, it was 28 and they were going to work something out. And I greatly appreciate, my client greatly appreciates going to 6,600. But I'm here before the board and I'm telling the board, the fine was originally $25 and the reason why I'm involved is because, as you said, there was a foreclosure issue, so then he had to talk to a lawyer, he talked to me, and we're here. But before that, he never had anything pushed against him. He wasn't backed against the wall like many people are today, right? So while you may be right, I'm not saying that ignorance is any excuse for the law. We're just appealing to the board's good judgment.
okay. May I ask Mr. Thornton
Yeah,
a question?
can we want to give other board members?
Yeah, I understand. I want to ask one question, Rick. How much is the out-of-pocket expenses the board incurred on this?
In terms of certified mailing costs, that'd be about $180. That would be $5 per letter that was sent out for each of the 36 reports. I understand from legal counsel that attorney fees might be in the neighborhood of $750 approximately, and court fees might be another $150.
So that would be $900, $1,080?
Yes.
All right, thank you.
Thank you, Commissioner. Any other board members?
No, I think, thank you for sharing that, and I agree. It's not black and white. I agree with Commissioner Scholes about the idea of we actually, in the time that I've been here, I've had the privilege of seeing individuals who run for office, who do things that I would never do, and it's run for office. And I appreciate that, but I also think that as we've had conversations with Rick, it's the idea that several letters were sent even before we went to judgment, and so I think that, and that is something that we have had conversations with individuals that owe less and have had it. I think this regulation is a right step. I'm glad that we're able to address it even further. I don't, I wish I knew I could do the math enough and have the reports in front of me. Even if we did $25 for every report missed, I think you mentioned it briefly, and $2 after, it would actually probably be a lot more than $6,000 over a decade of years. And so even if we did that remedy, I think right now that the figure that we're being shared by the director it fits. I think that this, as a board, we are working on how to address this better, and it's a very difficult first case, but I appreciate sort of the work that the entire board has done for it.
Thank you. Do you have anything to add, Commissioner?
Madam,
Madam Chair, the only thing that I'll add is I am familiar with the defendant or the respondent in this case. I don't have any economic ties to him, nor do I have any economic ties to John. John and I are first cousins. I do sympathize with Mr. Grish's plight. I've had actually campaigns, including John's, where he was the opponent. So I do understand that it is unfortunate that he had just expended his own money. Just based upon the appearance, I will be abstaining from the vote. I sort of get the feeling that my fellow commissioners have in this regard, and I know the commission is trying to establish a process that's going to be towards everyone. I will say that in this particular case, the thing for me that was the most concerning was the fact that he didn't raise any money. And I'm certain there are a vast number of candidates who use their own money and end up, and I won't say not reporting, but not reporting all that they use. But be that as it may, I would, I defer to my fellow commissioners on this, but again, I do know the circumstance that Mr. Grich is in.
Thank you, Commissioner DeSwan. And I'll just add and say on behalf of myself and the board, Mr. Grish, thank you for your, willingness to engage in the democratic process. I also agree with you, Mr. DeSwan. It's not always black and white. It's not always an equitable process. I think we're working towards that because any, citizen with an urge to represent their constituents in some fashion should be able to run. And I think it's unfortunate it's gotten to this point, and hope that with some of the work we've done on the process and the structures, along with taking into account we are all humans, and getting to this point that I hope, we can walk away today with a reasonable judgment. So, that both Mr. Grish and his family can move forward in their lives and, rebuild what they need to rebuild. And also the board can have, a way to move forward to assess that in the future. So just, again, want to thank you and definitely empathize with life and circumstance, that things that come our way that we don't always expect. And with that, does anyone else have anything to add from this end? Rick? Commissioner
May we
Schultz?
hear from Mr. Grinch?
The only thing I can think of is that when this initially, my life for the last 25 years, we were blessed that me and my son's mother, both almost 50 years old, had a child. So then my parents got sick, and I was torn between paying attention. The most important thing was everything in their life. And the second month after his birth, I lost all my fingers on my hand. So it's been a struggle just to function in this world. And when my parents got sick, and I had a lawyer, Earl Passback, who I didn't even know, my father was in and out of the hospital, that he had passed, and he had a court date to resolve this 10, 12 years ago. And it took a long time to even know that he had passed. He just simply said, I'm going to appear in court and should be able to resolve this from you. That's got to be 12 or 14 years ago. I don't want to say I was dumb, but I didn't know all the facts. And if I had known that this would accumulate to that, I had enough common sense to just address the issue before it got this far. But every day it was, take care of my dad. The house that John is trying to help me deal with, we put my sister in. She lived with him 24 hours a day. My dad, he had 14 years with Alzheimer's, and I had to take care of him. My sister's helped, and then it was my mother's help. And soon after that was my mother got cancer. So it's been a long 20 years between my hand and how to, survive, for my family, so I lost track of a lot of things over the last 20-something years.
Thank you.
May I have a few questions? How old are you?
I'll be 72 in 2 months.
Are you working?
No, I had supposedly, they said a year ago, 2 heart attacks, broken ribs, broken lung, my appendix ruptured. I'm dealing with vertigo and some intestinal problems right now. So, but I'm lucky because after all those things, I'm still talking to you. That's the way I approach it. And I got a wonderful son. But my two sisters are, she's dealing with Alzheimer's now, and the other one is not too far behind. So still, that's what I got up here. So,
Well, thank you very much. It's a hard case.
Thank you, Commissioner Scholes. And just one more thing to add, I'd be remiss if I didn't, say that I think where we are now and the staff, and I hope you felt that, Mr. DeSimone and Mr. Grich, that this campaign finance staff led by Rick really do work hard to support people, knowing that it is not a level playing field. So just wanted to not let that go by without saying that to you, Rick. And yeah, no, I figured you would. And if we don't have any further questions, do any board members wish to make a motion on this case?
Madam Chair, I just have one question for council. Ray, when you suggested treble damages, you suggested that is that as a maximum? Is that something that you're suggesting in this case?
Both. Unless I'm missing something, the statute of 1725-16 reads as not to exceed 3 times, and then that means that you can apply it as you see fit, but that would be your ceiling, both for here as well as I hope we have a regulation that actually does this. I'm sure we'll work on that we will make that part of your
That was
formula.
going to be my other question. You're suggesting putting that in regulatory?
Very much so. I think we should have some kind of a cap, given that while we fully expected that the formula itself would be sufficient, it does seem like there are going to be cases where the activity will just not be that high, and you'll have to address it in another way.
We have to come up with a number.
Well, we're an open meeting, so we have to just
Mhm.
be as loud
Yep,
as
yep,
possible.
we're just,
with our-
Yep.
Conferring over here.
You're not. No, you are.
Thank you. All right. Well, given the circumstances, we're good here? Well, I'll say, given the circumstances, but we also have to take in consideration what has happened over the last 20 years. So we've been no really communications from him for 20 years on these issues, except for filing some reports, and they're all late. So right now, get a judgment for 71,000, okay? Under the regs, it's reduced to 28,000. If we apply the formula set forth in Rhode Island General Law 17-25-16, that would be about 6,000. Okay, and that'd be the trouble if that. And we have $1,080, and now it's out-of-pocket expenses. So I think maybe under the circumstances, if we have a fine, let's say 5,000 plus 1,080, so it'd be $6,080.
I'm sorry, can you say that again?
$6,080.
The 5,000, where did you get that 5,000 from?
Oh, I just came up with the number
Oh,
5,000.
got it. Sorry, I was like,
Okay.
did I miss a number? Got it.
Because, the statute allows treble damages up to 17-25-16. So if we come up with a number like 5,000, we know out-of-pocket expenses 1,080, so that'd be $6,080. And that would be obviously subject to the sale of the house. Okay, so we just give that number to the closing officer in return for a release
Yes.
at that time.
Go ahead.
No, it's just based on Commissioner Scholl's numbers. So that makes sense. I guess I would say that rather, because that's why I was like, where's the $5,000? I wonder if just for purposes of any other cases that may come in front of us, I wonder if it would be, because if you say 5,000 today, are we creating something that in another time somebody might say, well, where's that? We want the same $5,000 and then go from there. And so I'm wondering if you would be okay with just doing, because your figure is 60/80, right? But if we do just treble damages, the treble would be 6,600, isn't it?
Yeah.
I guess for me, it would be an easier math going forward, to just say 3 times the original, the original sort of expenditure.
So you
I
say,
think-
6,600 plus the out-of-pocket expenses? Is that?
No, thank you. Thank you for clarifying that. I was just gonna say just, at least for me, it would just be the 6,600, just without the out-of-pocket expenses.
I think there's, and I'm struggling too with you, I understand the out-of-pocket expenses. I also understand the principle of the non-compliance, non-respondents. And I'm thinking about balancing some of what we've heard with the fact that it's not black and white, not everyone's created equal. So I'm wondering, they're just
Yeah.
popping another 5,000 out of your head, frankly, onto the 1080
Yeah.
when we've heard a lot today and learned a lot. So
'Cause
we have to balance the precedent
Yeah.
with the fact that every case is a different human with
Mhm.
different circumstances, with different means.
Yeah, because I agree with the commissioner about like the idea of why we would charge out-of-pocket expenses. I do. I completely agree with the idea of why that would happen. Again, it's been a very long time and several, things were done. So I don't disagree with wanting to charge that. I think that because your math or sort of like your proposal, the commissioner's proposal, it's nearly the equivalent of what just a treble damages would say. I guess my recommendation would be for this
Mhm.
specific case that we waive the out-of-pocket expenses, but it doesn't mean that for any cases going forward, we would have to waive those out-of-pocket expenses. So I guess my recommendation would be doing the treble damages, and in this specific case, just waiving the out-of-pocket cost, which would take us to a very similar figure.
Yeah, I think the point is to arrive at a number.
Yeah, I agree.
Okay, because the actual number we don't break it down.
Yeah.
When we issue the release. So it's the number that's the important factor here. So $6,600, sure.
Mhm.
That's-
That would be my recommendation.
Go along with that.
Chair?
Yeah, I mean, if you're making, I think it's too much, but if you're making that motion, you can make that motion.
Do you have a recommendation yourself?
Well, if we take the 6,600,
Mhm.
subtract out the out-of-pocket cost, that brings us to where? Somewhere in the vicinity of 5,000?
Yeah, it's
5,000,
5,500.
Yeah, 5,520.
Can I make a motion?
Of
No,
course.
I didn't think so.
Ordinarily
why I
not,
never
as the
thought of
chair.
it.
Yep.
So this is just on us not to make a motion?
Think-
Well, we have Marcel requested 6,600.
6,600, yeah.
This question is, we don't want to set a bad precedent
Mhm.
because a lot of people owe money. And they
I know.
they don't bother responding and they don't bother reporting or responding to the communications from
Well,
Mr. Thornton. So
I
we
understand.
can't ignore all that.
No, I understand we can't ignore it, and we've had plenty of people sit before us in a similar fashion with reductions
Yeah.
that
No,
we've reduced.
Mhm. Agreed. No, and I
No.
agree. Yeah, no, that's because then I think that's a good point. And I think Mr. DeSimone mentioned that earlier, right? It's to our discretion, and we have done this, right?
Yeah.
In closed session, we've had this conversation about individuals And that's why I would say that for this case, I would feel comfortable sort of waiving the out-of-pocket expenses because as Ray said, we created a formula we thought would work for everybody. It doesn't, but this at least creates a path for a formula of cases that will be very similar. And that gives us the option of charging the out-of-pocket expenses or not. But to this, I would say it would, I would recommend that we do not charge those in this specific case. So that's my,
Madam Chair, just another question for Ray. Do we have the ability to charge out of pocket under the statute?
The statute speaks to reducing the fines and penalties, which you're doing. It doesn't say how you factor that in. If you're factoring in so that you're well below the fines and penalties that would have been statutorily imposed, applying something as reasonable as a court cost would, in my judgment, be appropriate. Again, given what we're talking about, I'm thinking we might have a few things we want to change in our regulation. So that we can actually specify that. So with that being said, probably the safest way is to look at what the costs were, factor something on top of that if the board thinks that's appropriate, beyond the 2,200, whether it's 6,600, something below that, but that I would say is your ceiling until we can get the regulation
the 6,600 would be our
ceiling.
Yeah. So that's my motion, I guess.
Can I ask Ray a question?
Yes.
I thought on the statute, the court would award up to treble damages plus costs. Is that what the statute says?
Well, we can pull it up then.
Yes, please
I
do.
don't
Yeah.
remember that, but if that would be reasonable. I think we just have to be mindful that what I came up with was a way to try to address our first case when we have a purchase and sales agreement, we have a pending lawsuit. The best approach, obviously, is just to rewrite the regulation and then apply it. But I'll look at that right now and see if what the statute says on that.
And just to clarify, also, I guess for Rick, just want to be clear that when we do decide today on an amount and take a vote, you would work with Mr. Grish to could be on a plan of payment that extends.
Well, I believe,
Past.
wouldn't the board receive its funds upon sale of the property?
Upon sale.
Yeah.
Yeah, we would do that.
Yeah.
Okay.
And I think the whole purpose of this, because the sale is pending, it would be paid immediately at the sale.
Let's hope
Yeah.
it goes through.
Yeah, we're hoping so too, for everyone's benefit.
Okay. Yeah, but this is it's a
Yeah.
delicate balance, it's a delicate situation. And thank everyone for wrestling with it. So we have a motion, Commissioner Bettenker, can you just repeat
I
it?
will, I
Sorry.
make a motion to reduce Mr. Grish.
Grish.
Thank you, Grish. It's all right. My last name is not meant to be in English, so I thank you. Mr. Grish's fees to $6,600.
I'll second that.
And while that's pending, I am looking at the statute 1725-16. It doesn't reference costs, although I do think that's reasonable. It just references imposing a civil penalty not exceeding 3 times the amount of 1, contributions made or accepted in violation of the chapter, 2, expenditures made in violation of the chapter, and/or 3, contributions or expenditures not reported as required by this chapter.
Thank you.
Thank you. Okay, we have a motion and a second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye, and 1 abstention. The motion passes. Thank you, Mr. Grish.
Well, I was going to thank you for, dealing with my problems over the last 20 years. So I'm sorry that, we actually met this way. Wasn't the way I wanted my life to go the last 20 years, but just been lost for me for the last 20 years.
Thank you so much.
Thank you.
maybe I can run for office again.
Well, on behalf of John, since I was on a couple of his campaigns, we'd like to thank you for running
Well, I
again.
don't feel familiar. Well, at times, I know when I ran for other people, they wouldn't agree with your sentiments there, but I
That's
just
funny.
worked hard at whatever I tried to do.
Thank you. We wish you all the
Thank you.
best.
very
Thank
much.
you. Okay. Next item on the agenda, the board may discuss and vote to approve the minutes of the meeting held on April 2nd, 2024. Do we have a motion to approve the minutes?
So moved.
Second.
Moved and seconded. All in favor signify by saying aye.
Aye.
Aye. Motion carried, minutes approved. The board may discuss and vote to approve the minutes of the meeting held on April 11th, 2024.
Motion to approve.
Moved
Second.
and seconded. All in favor signify by saying aye.
Aye.
And I will abstain. That's okay. I was not present at the meeting. Okay, motion carries. The board may discuss and vote to certify the results of the logic and accuracy testing for the Cranston special referendum to be held on Tuesday, June 4th, 2024. Executive Director?
Good afternoon, members of the board. Logic and accuracy testing of the early voting and the election day voting equipment for the June 4th Cranston special referendum began last Thursday, May 2nd, at 10 a.m. and concluded the afternoon of the same day. That testing was open to the public. One ES&S employee and 2 BOE staff were involved in that testing. 12 DS200s and 6 express votes were tested for the polling places, and 2 DS200s and 1 express vote were tested for the early voting period. 2 additional DS200s and 2 additional express votes are available as backup units. Additionally, we did test 2 DS850 high-speed tabulars for mail ballots, and a total of 27 machines were part of this testing. The test deck this time consisted of 7 ballots inserted into each DS200. 2 of these ballots were express vote cards for a total of 84 ballots in total used for this testing. 30 ballots were also processed through each DS850 high-speed tabulator 10 times. During the testing, we did have to replace 1 express vote unit due to a faulty touchscreen, and 2 DS200 units were replaced during testing due to touchscreen and modem issues, and those items will be repaired prior to the September primary. The Secretary of State's Division conducted a review of the express vote ballot information per our protocol, and on May 1st, they certified to us that the information on the express votes, the ballots, and the accessible ballots are accurate, which is in accordance with our testing protocol. Before each machine is closed, locked, and sealed, at least 2 members of our staff visually confirms that the totals report printed by each machine matches the expected results on the result key, which you have, and that the machine has been reset to 0. Our election management system is also reset to 0 as reflected on the following reports. As required, ES&S has given us 3 reports, which you have before you. The title of each report is located at that top right-hand side. The first report is the pre-0 report, which is printed prior to testing. The second report is the LNA testing results report, which shows the results, which has been compared to the key on the voting results report, which you also have. These results match. The third report, titled LNA Testing Post-0 Report, shows that each machine and our election management system has been reset to 0 and are ready for operation for the special referendum in Cranston. Our staff will deliver the early voting equipment and supplies to the Pastore Youth Center on Monday, May 14th. Early voting begins on May 15th. Staff will deliver the polling place equipment on Monday, June 3rd, and pickup will begin the day after of the election. At this time, if the board has no questions, I ask that you certify the voting equipment for the Cranston special referendum to be held on Tuesday, June 4th.
Thanks, Miguel. Any questions for Miguel? Do we have a motion?
I have one question, Miguel. How many voting stations are there, or will there be on June 4th?
6.
Okay, right. I move we accept the report.
Moved and seconded. All in favor signify by saying aye.
Aye.
Aye. Any opposed? No, the ayes have it. Motion carries. The board may discuss and vote upon the recommendation from the Legislative Subcommittee on Legislation H-8118 pending before the General Assembly. Commissioner Bettenker?
The legislative subcommittee voted to support the 8118 with some staff recommendations to, with additional changes to the legislation, which is right now only in the House by Representative Kazarian and introduced or with the support of Common Cause. Common Cause was in agreement with the changes, and the staff and the committee support piece of legislation with those changes.
Anything to add?
Nothing to add. No,
Okay.
we had a very brief discussion. I think that the indication was made to us that it probably was not going to go forward this year, but it's something that the committee will report on at the end of session.
Do we have a motion to support the
I will
legislative
make a motion to
subcommittee?
support 8118.
I'll second it.
Okay, all in favor signify by saying aye.
Aye.
Aye. Motion carries. The board may hear public comment on the rule and regulation 410-RICR-20-00-28 risk limiting audit.
Members of the board, the staff has reviewed the proposed public comment changes submitted by Common Cause and by Verified Voting. As you know, Verified Voting is an organization who we partner with to conduct the risk limiting audits. And based on our conduct of the presidential preference primary audit, we did request that they provide some feedback in terms of implementation of the regulations. Now, these regulations were not in place for the presidential preference primary audit. However, because the staff has worked with Common Cause on developing these regulations, we voluntarily abided by the regulations. But in the conduct of that RLA, there were some instances where we found in conducting the risk limiting audit in conjunction with Verified Voting that there are some things that would need to be tweaked. And this document that you have before you from Common Cause and Verified Voting is based on that feedback that they provided to us. The staff had no issue with most of the suggestions here. The only item I will note, which was in the original regulation, is the requirement that we provide written notice to the party chairs about the nomination of essentially volunteers or audit board members for the audit. The board for many, many years has not been under the requirement to send written notice to the party chairs. We generally send them to an email inbox that the party chairs have, or to the party to the general inbox for the parties. That's how we notice them for all our meetings. Certainly, it's something that we could do, but I will note that it's not something that we typically would do in most instances, to send them an actual paper mail through the snail mail. And I know that part of the suggestion is that be changed from written notice to via the U.S. mail. We would certainly send them an email probably, because it would probably get there before it would probably be read by someone before the actual postal mail is read. But in practice, we generally send emails to the party chairs. The other issue, which is not really an issue, but just a note that this the suggestion is that we show during the live stream of the audit, we have a staff member sit in front of a camera, which this changes certainly make that optional. We don't have to do that, but we do try to do that when technically possible. It requires that we actually show the ballot, the tally sheets being read by that staff member, and show the actual software tool, the information being entered into the software tool. So essentially, you would have to have a split screen. We were not able to achieve that because of a technical limitation of YouTube. We are possibly able to achieve it with using Zoom, which is another platform. But our goal was to do that, but we weren't able to do it for the presidential preference primary. So I will just note that although that is in here as a requirement, and we will certainly make every effort to do that, we are bound by the technical limitations of the software products or the service that we use. But that's our goal, is to show the actual tally sheet and to show the actual entering the numbers into the software. But other than those small minor notes that we made, we have no issue with any of these suggested changes, and we think they make the actual conduct of the audit better.
And Madam Chair, just so we are clear, we should make sure this is part of the record. We're talking about, Miguel, we're talking about which documents for the proposed changes?
So the Common Core submitted to us from recommended amendments to the regulation based on feedback in the conduct of the presidential preference primary risk limiting audit. They submitted that publicly to us, and we distributed it to the board. The staff has reviewed those, and again, we have no issues with any of the items that are
The one of May
Suggested.
7?
correct. May 7th letter.
And
And are
then
they-
there's one of September 26 as well, right? Is that-
Yes,
Okay.
that's the original. This has been in process since September of 2023.
So Madam Chair, we should make that part of the record. Somebody should move to introduce the letters so that they are part of the record on this motion.
Okay.
I'll move to introduce the letters as part of the motion.
I'll second it. Would the movement also consider, well, all right, I'll second it for these purposes, but then I have another motion because we need to put this in final form, correct, right?
Yes.
So those have to be, right.
When does that end,
Yeah.
Patty? Okay.
So
June-
if the movement would consider having those changes adopted into this for the June 7th, is there a June 7th meeting as well? For the June 7th meeting, and then we'd be able to consider it in final form.
It will be at some meeting in June, correct? It might not be the 7th, it might be a week after that. It depends on, we have a deficiency requirement, a notice requirement to hold a meeting regarding for the Cranston special referendum, so it might be on that same meeting date.
So if maybe we could add those changes in with the exception of the mail.
Well, we can do the mail, but I was just letting the board know, we will probably send it by email as well, above and beyond what the regulation.
I mean, look, I for one am not in favor of putting in the mail notice, but that, because I just think it's superfluous and I don't think it matters at this point, but,
You
I'll defer
you
to
can
this.
certainly choose to, I mean, John Marion is here from Common Core, so if he has any input into that,
Can we just, should we close out the,
The motion. for-
yeah, there's a motion to introduce the letter
I second.
onto
it,
the
so-
record. Second, all in favor signify by saying aye.
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 Aye. Okay. Hi, John.
Yeah, that's actually the two letters, just so
Oh,
that we have a,
The
right,
September
there's
and
a
the May.
September
Yeah, the
26.
September letter.
It may have already been
was included
introduced,
as
yeah.
an attachment, but it was for the reason, I wanted it in the record
okay.
because it instigated this. Yeah, I, had communication with the Secretary of State's office about our proposed changes. And they had, just indicated that the original proposal said written notice, and that wasn't necessarily clear if it was postal mail or email. Both could be considered written. We have no preference if it's
Okay.
email or postal mail. Whatever is practice works for us. It was just an attempt to clarify.
Sure.
And if I could make just two other brief points. One is, I know the Secretary's office does have one other suggestion with respect to the timing of the audit in the fall and making sure things are done before the Electoral College, and maybe fixing that language. And I talked to Rob earlier today, and we're totally fine with his suggestion on that. So they have some language there. And then just finally, a point I made in the letter, this is under the APA, unlike most of what you do in terms of regulations.
we consider these suggestions as the logical extension of the original rule, which would mean it doesn't need to go out to notice and comment again.
Thanks, John.
Yep, thank you. Thank you.
May I ask
Yes,
the
sir.
director a question? Item number 6, which is the rules and regs regarding risk limiting audits. It's all in red, all underlined. Is this the proposal from Common Cause?
The version I have is not in color, so I believe that might be the nomination paper
No.
version.
Oh, this is the
No,
red.
these are the-
No, this is
Oh,
the.
sorry.
This is the
I don't print
regulations
it
are-
out black and
Are
white.
you
risk
asking if it incorporates the suggestions in the
Well,
latest?
no, well, first of all, the question is it all from Common Cause, the proposal?
Correct. They attached that to their correspondence, yes.
And I know the staff made some recommendations.
Very
But-
minor ones, yes.
Is that included in this as well?
Not yet, no.
Okay.
Yeah, this is the rule right there on the Secretary of State's website. It's all in red and underlined because it shows it's a draft. So we're gonna stay like that until it becomes adopted.
Right, yeah. I was just curious because if the staff made recommendation, it would be in blue.
So we would make our recommendation, but we will also incorporate the recommendations that we agree with the Common Cause, which we agree with all of them. So, except I believe we're going to leave the written or make it clear if the board chooses to, that email communication to the party chairs is sufficient. It does not have to be a written communication by mail, excuse me.
The only other thing I would suggest, Director, is that with regard to the technology, that there be some language in there that gives the staff some leeway on the technology. I mean, obviously, if you can do a split screen, that's great, but if the technology isn't, I think the regulation should address that. That if the technology doesn't make it possible, that you'll make every effort, but if the technology doesn't make it possible, then you can't. I don't want us to be in non-compliance with our own reg.
So we can certainly put when feasible in there, that when it's feasible, we will do both of those views at the same time during the audit.
Okay.
We do that.
Okay.
I think the Secretary of State's have the comment. Do you want to go to this one? This one's green.
Yes, thank you. Thanks, Chair. And members of the committee, Rob Rock with the Secretary of State's office. Just to follow up on John's point about the Electoral College, I first want to thank John for incorporating some of our suggestions. But one minor change we want to make is that because the Electoral College this year is going to take place on December 17th, and there's a bunch of paperwork that the board needs to sign. So we're hoping that we can alter the language just a bit, and I can provide that information, that if auditing the presidential contest, the audit must take place in a timeframe that allows the board time to certify the election in order to comply with all Electoral College requirements. The language that we had given John originally talked about making sure it was done before the Electoral College, but I think it needs to be more specific to ensure that we can get the proper documents to Washington ahead of the Electoral College vote.
Thank you.
Thanks.
And once we get those dates from the Secretary's office, then we can incorporate that more specifically into the regulation.
Okay. Anything else? So we don't have a vote. We're just hearing public comment, right? So we can move
That's right.
on.
I'll-
Okay.
That's correct.
The board may discuss and vote to modify the rules and regulations 410-RICR-20-00-10 nomination papers and commence the public comment period on the proposed modifications.
Honorable members of the board, before you today, the staff presents amended rules and regulations for nomination papers. As you know, during the 2022 election cycle and during the 2023 Congressional District 1 special election, the nomination process became marred by allegations of fraud by signature collectors occurring in some communities around the state. During both election cycles, the board faced a multitude of objections filed by candidates, both against their opponents' papers and against the disqualification of signatures on their own papers by local boards. State law currently requires that the board render a decision within 2 days of the filing of objections, which was nearly impossible given the number of objections and the vague content of the objections filed in many cases. In the 2022 election cycle, we received 10 objections, which had to be researched and decided within that 2-day period. In 2023, during the CD1 and the Senate special election in Providence, we had 8 objections filed, which likewise had to be have a decision rendered by the board within 2 days. In January of 2023, the board submitted legislation to the General Assembly to extend that deadline to render a decision to 3 days for primary candidates and 7 days for candidates not facing a primary, while also implementing additional requirements on objections. Unfortunately, that legislation did not advance through the General Assembly. This legislative session, after input from the staff here at the Board of Elections, the Secretary of State introduced House Bill 7664, and the board voted earlier this year to support it. The bill would extend the objection process to 6 days for primary candidates and 12 days for candidates not facing a primary, and it would move the primary date into August. As of today, that bill has not advanced through the General Assembly, and there is no Senate companion bill as of yet. Some aspects of that bill have been incorporated into these proposed rules and regulations before you today, which the staff does expect to be in effect prior to issuance of nomination papers to candidates on July 2nd later this year. Some of the key changes I would like to highlight in this proposed regulation are as follows. We've added and clarified some of the items under definitions. The proposed regulations make clear that the signature gatherers must be at least 18 years of age. It requires that signature collectors provide their driver's license number or state-issued ID from any state, as well as their clearly printed name, address, and phone number. If they do not have either identification type, the individual would need to check a box indicating such. The regulations also affirm that under Rhode Island General Law 1714-8, an endorser must provide their name and residence as it appears on the voting list. Variations in the signature are still allowed as long as they're reasonably identifiable. It creates a process by which local boards should notify the Board of Elections of potential patterns of forgery, and the board or its executive director may notify other local boards or order a review of the nomination papers, which would be a board action. This language is modeled closely after the Secretary of State's Bill 7664. It requires a form upon which objections must be filed with the Secretary of State or the local board. This form is still being created by the staff. A written basis for the objection must be provided. We've added language stipulating that objections to signatures and sufficiency of nomination papers may be made by a candidate for the office or the chair of the political party. These proposed regulations also establish what specific evidence may be provided in relation to objections, depending on the nature of the objection. This includes a new Board of Elections form affidavit for a witness to sign and to present at a hearing. The proposed regulations make clear that all these requirements apply to objections filed for local contests at the Board of Canvassers and state and federal objections heard by the board. And finally, unfortunately, the deadline for the board to render a decision remains at 2 days, as the board is constrained by that time frame, which is currently still in state law. All of the changes within these proposed regulations have 2 primary objectives. First, to make abundantly clear to signature collectors that they are, whether they're a candidate, paid staff, or volunteers, that the collection of signatures on nomination papers is critical and important to the process of ballot access and governed by state law. It also makes clear to signature collectors that they are attesting to all of the requirements under the law. And these requirements are laid out at the bottom of each of these nomination paper forms. And that they will provide all of the verification and contact information necessary for election officials and, if necessary, law enforcement to contact them if there is a question about the validity of signatures collected on the forms they have attested to collected and submitting to election officials across the state. Secondly, it creates a clear framework for objections to be filed and heard in the most efficient, accurate, and fair manner possible. This is key because the board is still required to render a decision on all objections within 2 days. While the staff feels that 2 days is certainly still not enough time, The changes proposed within this draft regulation at least make compliance with that deadline more viable. I'm happy to answer any questions from the board on this regulation, and you should have public correspondence that was submitted by the ACLU and Common Cause.
Commissioner?
Yeah, thank you. So my question, I was just reading the agenda. So are we voting on some of the changes that are being recommended today?
So I'll let Ray handle that
Yeah,
as far as the
I
period.
just wanted a
Right,
clarification.
so we will keep the public comment period open.
That's right.
And I think that it probably would be better just to wait for that period and then
So we can have all
take,
of them.
do it all at once. Yes.
Got it.
We can discuss, we can ask questions and discuss and recommend to the staff to make changes to this.
Well, let's take a look about,
And also, Ray, do we need a motion to introduce the letter, or was this already in the, is this already on
yeah,
record?
Is that in the record, that letter, or?
the
The-
May 7 letter?
Yes, I believe it's
From Common
attached to the
Cause.
agenda. The
I'll move to include it as an exhibit.
Just in case. Yeah. I'll second.
All in favor signify by saying aye.
Aye.
Aye. David?
I think this is already in the record.
Okay. Well, if it's-
Well,
Is
we
it on the
received-
website?
This is a
We
separate-
received correspondence, I was, I believe, after close of business hours yesterday that we received the correspondence, so.
We're doing it just in case.
So I would introduce it just as an abundance of caution.
Zero and I. Thank you. Okay, I don't forgot who was.
So I believe the intention here is this is the starting point for these nomination papers. We're certainly still receiving input from the board and from the public and from the local boards and from the Secretary of State's office. I did distribute this to the Elections Committee of the City and Town Clerks Association last week, and I did submit it to the Secretary of State's Elections Division as well for their input. Certainly, they have input regarding the nomination papers. It's something, if you choose to hear from them today, or if you want them to submit written testimony or testimony over the next, I think the intent is that we would like to have the public comment period run until the next regularly scheduled board meeting, which is June 4th. This is not a regulation that is subject to the Administrative Procedures Act, so the board does have that, and Ray, correct me if I'm wrong, does have the flexibility to have that public comment period be between now and the next board meeting.
Yeah, we're not part of the APA, but we have, as a rule and a practice, we've always, I think, always gone with the 30 days. Here, we're off by, it looks like, one
day.
or 2 days, one day. And will this be posted with the Secretary of State's website now? I mean, will the public have 29 days if, they'll have 28, right? Because we'll be doing it tomorrow? Or, I know sometimes it can't always just be that quickly done, but,
This is a modification of the rule that's already on the website, correct?
Correct. This is an amendment, yes.
and does that get posted? I mean, will the public have 28, 29 days from?
They will have a public comment period from essentially now. We will take public comment on this via email, via written correspondence, or as we can find out tomorrow morning if it's the public comment can be received through the Secretary of State's portal as well. But regardless, we will receive public comment until
Right.
prior to the next board meeting.
Yeah, so we'll have 28, 29 days in, but I meant more like the reg itself will be posted publicly.
Yes.
So they'll have so the public would, not that, I have a feeling that everybody who would normally be providing comment, I know gets actual notice by this office.
It's like that other regulation, there's nothing on the Secretary of State's public comment. period. We really take-
Yeah, okay.
So we-
Yeah, so to answer Miguel's question, there is no requirement that it be 30 days. We always do that, but here, if we can be as close to it, and it looks like we can, that should be sufficient.
And we've, in the past, we've posted it on our website, which we intend on doing soon after this meeting, posted on the website, requesting public comment for it on our website as well.
So that would allow this to be in effect for this current election.
So there will be a period at the next meeting where public comment will be discussed, and then the staff will need a little bit of time to incorporate any of the changes that the board chooses to incorporate based on the public comment or the board's own action. And then we would have to have another meeting subsequent to that to present you with the final, with the version that incorporates those changes.
So Ray, if we have a request, should we be making that now? Or should we be
Well, I mean, it's
waiting
almost-
till the end?
Right. To me, it seems like it would be more practical to wait because otherwise, if you make some changes now, and that takes several days, let's say, to get those done or more, but let's say several days, is that where you're going to post for 30 days? Is it going to be I mean, it seems like it's probably better just to have what they prepare, post that, and then at the end, incorporate all of the changes that you wish to have incorporated. There's no harm in doing it that way. We don't have anything where this would affect any process, so that would make the most sense to me.
Okay. So I guess my next question is, what's the board's pleasure on hearing? I know the Secretary of State's office has been asked for input and John and Steve have submitted a letter. We heard from them the last time. Do we want to hear comments from them at this time?
I think the letter would be fine because I know that
Yeah.
Miguel also mentioned sharing it with other councils, and so I guess at the next meeting where we hear from everyone, it could be a lot of humans we hear from. So I don't know.
Madam Chair, the only thing I'd like to bring up at this point is I did read the discussion from Mr. Marion, Mr. Brown, and in 10.5, number 1, the language that says a consistent pattern of forgery.
Yeah.
I'm curious as to why we chose that language. I think it should be just suspects forgery, because I don't think that consistent pattern, well, one, I know it's not defined. And 2, I don't think that makes a difference. I think one instance of forgery is an instance of forgery. So whether it's 1 or 20, if the person forges documents, I think it's something we should be made aware of. So if a local board thinks, hey, John Q. Public forged this particular signature, I still think we may not take action on it if it's a single
They should
issue, but I
inform
think we
us.
should at least know about it. So that's why, one of the suggestions I would make, but I can certainly wait to do that until June. I was just hoping that we'll have this in effect for the current election. I don't want to get into a situation where we're in the same boat that we were in the congressional election. So, but as long as the director assures us that the staff is going to have time, then that's fine. I'm willing to wait.
In terms of the patterns of forgery, we base that off of the legislation submitted by the Secretary of State's office, which was done in cooperation with the staff here. I think the reason for the language and the pattern is because the statute addresses if there is forgery, the signature shall not be counted. It's very direct in terms of for the process of counting the signature for ballot access. So we're trying to strike a balance between when you have isolated incidents of a voter signing, their neighbor's name or their deceased uncle's name because they don't want to sign a paper, which is clearly in violation of the law. However, we're trying to develop and come up with a threshold that we would sort of put out that alert to the entire state about fraud happening. So where that lies, we're still trying to determine that language based on this draft. Obviously, there's going to be feedback on that, but we certainly know that we will receive reports from some communities that say they have a signature that does not look right on a paper. At what point does that warrant crossing that threshold to raise that alert for a particular campaign or collector doing that? And that's the balance that we're trying to strike in. That was our attempt to develop language that said it's a pattern, meaning it's clearly more than just an isolated incident. It's collectors who have multiple papers in multiple communities that have a clear a reasonable person would think there's something going on here that does not look right. And I guess we just need to develop, come up with that, ultimately what that language is to make that determination.
Madam Chair, I was gonna ask that. Like, I'm wondering if, because I also circled the same thing. I think if that's word that we're gonna use consistently, I do think it should be added as a definition as well. Otherwise, it could leave it up for what is a pet, right?
Yes, and I believe that was in the correspondence as well from the ACLU and Common Cause. They pointed that
Yeah.
out as well, so we can certainly take a look at that.
A couple of questions, Miguel. On my copy, we have some language in red and some language in blue. So can you tell us who proposed the language in blue? And the language in
So
red?
the staff, in essence, comes up with a first draft, a wish list per se, I guess you can say. And then, we show it, we discuss it, we show it to Ray, legal counsel, and there are things that are determined that can't possibly happen because of a court case, either something that went before the Supreme Court, or there might be different factors that require that. And then that would be changed. And if it is changed, then that's where you would see some of the different color variations. So the red is basically language that was added in after that draft or modified. The blue is some of the original language in there. So it gets a little confusing through the Microsoft product when multiple people are changing the document. We experience that ourselves. So, but that's why you see multiple colors. But it still follows the same pattern of underline is being added to the original regulation, which is, I believe, was enacted in 2010. And the strikes are striking language from that 2010 regulation.
So I take it after, assuming the regulations adopted, person making the objection, there will be a hearing directly at the board, but not before the local board of campuses.
This is for, in which
And
instance?
the objection to the signatures. Where would there be a
For-
hearing
for-
before the board of campuses on an objection to signatures?
For local candidates, yes. For state and federal, we would still handle that at the state level.
So assuming there's a hearing before the local board on local candidates, they don't like someone doesn't like their ruling, there would be a hearing before this board,
Correct,
hearing de novo, and that would be subject to these rules.
correct.
Correct. There is a reference in the rules that the board will prepare a form for the objections. Says that the objectors to the signatures must be submitted on a form prescribed by the staff and must include a written basis for the objection. Would that form be part of the rules and regulations?
It would not because, the intent at this point is to not have it included, with the reason being that it would allow the staff to update the form, or as long as it meets the requirements that are provided for in the regulation, we could change it or modify it as needed over each election cycle.
So that form would be used by this board, okay? Would that form also be used by the local boards of campuses?
Yes. And the intention behind the form is primarily because in the past, we've received just a letter. Sometimes it's a handwritten on a piece of paper at the counter at the Secretary of State's office at the local board, or, it just might say, I challenge all of my opponent's signatures. And there will be no basis, there will be no written basis for the challenge. So then we would have to reach out to the candidate and say, what exactly are you challenging? And then that's time lost. So what we're trying to do is formalize a process where they have the form. It explains to them, you provide your information, your contact information, what exactly are you challenging? Which signature lines are you exactly challenging? And then when they come here to the hearing, if they have any evidence to support each of those specific signatures they're challenging, they can provide that at the hearing, or preferably prior to the hearing, so it could give us time to further research it. But that's the purpose of the form, to more formalize and make it standard when they do submit that objection, that we get the same information from all of the different objectors, whether it's against their opponent or whether they're objecting to the local board disqualifying them. for the office.
One other question. Assuming the rule passes, what would be the effect, if any, upon the format of the nomination papers?
So the nomination paper is actually listed in here, which I have a copy of the current version here, is something that is subject to the approval of the Board of Elections, that is listed in here. So that is something that if the board wants something specifically on that form, then we certainly, I would believe you would have the authority to require that, which in the past, working with the Secretary of State's office, as we have this code, these codes that are at the bottom here, we worked with their office to put those standardized codes. So we would be able to still make modifications to that form based on the language in the regulation.
Thank you very much.
You're welcome.
Anyone else? No?
Rob, do you want to provide your testimony now?
It's not up to me. It's up to you all. Sure.
I'll be quick. So first, I want to thank Miguel and the team for working quickly to get these in place for this year's election in case our legislation doesn't pass. So just three quick things that we want to mention. The first is in section 10.3, where it talks about the definition of nomination papers. And it does talk about nomination papers issued by the Secretary of State. And we just want to make sure that that also includes nomination papers issued by the local boards of canvassers. And I think maybe the definition already does that because our office oversees the voter registration system, which is where these nomination papers are generated from. However, I just wanted to point out that it does say that nomination papers are issued by our office, but in many cases for state and local races, they're issued by the cities and towns. Section 10.4A talks about adding the requirement for the circulators to provide their driver's license or the state ID number onto the nomination papers. And we have a concern on that because these papers are public record and they're quite often sought by candidates, whether they're looking to challenge a candidate or looking at their own papers. And we feel that if that was put on there, we would have to redact, and the cities and towns would have to redact that information before providing the nomination papers out for public disclosure. And one of the challenges that Miguel mentioned a little bit earlier is that currently, and if our bill doesn't pass, it will still be in play for this year, where you all only have 2 days to adjudicate a challenge, which means we have less than I think it's 3 hours from the time that the local boards certify the nomination papers to us before we can provide copies to candidates. And if we had to redact hundreds of pages of nomination papers before we provide them to a candidate looking to challenge, it would give them less time to review them to decide whether or not to challenge. If there is a desire for the board to require a driver's license or state ID, perhaps it could be a separate form affidavit that would be given to the cities and towns on a private basis, so you can use it internally, but not for public dissemination.
Can I ask before you continue, where did that, to staff, I guess, where did the, thank you, thank you.
Yeah. No, I know.
How did
You're
that
brilliant.
come into the,
Over the last few months, since this has been since late last year, and what we went through in 2023, it had come up as a suggestion by some board members as a possible remedy. So we actually thought it was an idea that was worth putting in here in the draft. Certainly, if the board feels differently, but that is just one mechanism that we agreed could possibly make it the collector be more feel as if they are executing this affidavit on this form and they're providing this information that will be able to be linked to them if and when there is some sort of investigation either by the state board or by law enforcement.
okay,
Yeah,
thank you. Go ahead.
There's a need to try to make sure that if there is going to be an investigation, you're going to have access to the people who are involved. One way you can do that is by making sure every collector is a citizen of the state, an eligible voter, a number of requirements of that nature. That probably would not withstand a legal challenge. While the Supreme Court hasn't directly ruled on that, virtually all of the other federal courts that have stricken requirements that a collector need be a citizen or a voter. So what else can we do if we remove that from the equation, possibly by having some way of identifying the person, even if he's from out of state, so that we can get to them and get information if needed?
Madam Chair, what I was going to ask is there a mechanism by which we could require that information be submitted to the local boards but not put on the nomination papers? If there is, and I don't know if there is, I'm asking the question. I
Like a
guess I'm
second-
asking our director, and I guess I'm asking the Secretary of State.
We
And since we have someone from the
From
local
the
board in
cities.
Cranston, I don't know if there's a mechanism by which we can do that.
We did receive a similar suggestion from the Warwick, clerk of the Warwick Board of Canvassers. Clearly, that could be done. It would be logistically, though, it would be burdensome as well, because that form, if you have a collector submitting papers to multiple cities and towns, they would have to submit that documentation to multiple cities and towns, and that would have to be on file. Obviously, that could have the PII on it and would not be subject to the same, it could be released, but it could be redacted. It would be much less than nomination papers, but that would be a logistical process that would have to be worked out if that were to be implemented.
It sounds from, I think, what Rob is saying, that, and Mr. Commissioner DeSimone's, they would both be more time for the cities and towns. And again, we don't have to make this change today, but I wonder if as a full board, it would just be easier to not have that requirement. Again, either that or make the requirement that would be a second, as you mentioned, a second document, second paper. Yes, it absolutely creates more work, but it protects the person's identity when we're all trying to see documents. So otherwise, it just seems like that one seems like a lot more work, and something can slip.
I have a question. I think that's Ray, a question. Is the driver's license a public record? Can the public get a copy of the driver's license by submitting a request to the Department of Motor Vehicles? Yes.
I don't believe so. I mean, I think that there is, the privacy interest outweighs the interest in the information. So there are a number of cases on point. I'm sure there are many or some that deal directly with driver's license, but I'm thinking of even commercial licenses. I know that in at least one case decided by then Judge Dendelia, he had all of the personal address information on commercial licenses redacted before it was released, and anything, including the addresses, would be considered personal information that has a privacy interest, because, as the courts have ruled, is this information going to determine how government functions? If so, then you have something that could be released. But many times, the private information on a citizen would not rise to that level, and would be just sealed or not available as part of a public records request.
No, I don't think that's absolute, because the driver's license appears on police reports. Someone's involved in an accident, drivers, witnesses, little blocks in there, and you put the driver's license, the state.
Right, it would
and
just
all
be
these things are
redacted
information.
before it. I imagine that some of that would be redacted before it's produced, but certainly the police have the right to gather that information. I
But
agree with
the
that.
copy that the police will, that will disclose, that information is not redacted. It's included as a means of identifying the drivers, the parties. So I don't think it's absolute, but it's certainly a way of identifying somebody. And in this case, we have, how do you identify the gatherer?
Right, the agency.
Especially somebody who does not have a permanent address.
Well, I mean, if I understand your question, I mean, the agency certainly has the right to gather the information, hold the information, use it for verification, for accessing the person who may have been a witness to a fraud or something else. But I think the question is, can it be released to the public normally that would be redacted.
Mhm.
That the personal information would be redacted from the document itself. Not the gatherer's name, not the notary's name, but the personal information would be normally.
The problem with the license number, as I think is the concern of the Secretary of State, is if I have a license number in someone's name, you then have their date of birth. If you can access that license, and you probably could, once you have the number. And that'd be a concern, I think, for identity theft, things of that nature. But certainly the agency can keep it. So I think that's why I was trying to figure out if there's a means by, or some mechanism by which we can have the collector submit that, but not be part
Or
of
show
the
it.
nomination papers, either show it or have the board record, the local board record it, or however they're going to keep it, because I think they have a right to have it. I think, right, like you said, it's not dissemination, it's just the agency holding it.
Mhm.
So I mean, maybe we can come up with something, but I could see
Yeah.
the concern.
Do you want to keep
Yeah,
going?
yeah, just have one more, and that's the, who can make the challenges? I know that our bill does include written authorization from a candidate, so if a candidate is unable to make it, I know the current regulations, and I think the current law talks about a candidate themselves or a chairperson of a party. Our concern is that if it's a primary, let's say, and the chairperson of the party may not want to get involved in some sort of challenge, and if the candidate's unavailable to challenge, that would leave nobody able to make a challenge of a case. So we would just propose adding written authorization from the candidate given to someone representing the candidate to make the challenge. And we're happy to, we're going to submit these in writing as well so that it's documented for the board.
Yeah, and sorry, I have a question. My brain, I'm sorry. Based on what you just mentioned, Rob, so if, I guess what I would ask in writing is that if you're saying someone on behalf of the candidate, it would be helpful, like who that someone is.
Of course.
Is it someone in their campaign that has been, I would want to know who in their campaign.
Of course, and we could work with the board staff on that form that you're putting together, the challenge form, that we could have a spot that would say, if it's not the candidate themselves or the chairperson, who is it and what's their affiliation to the
Yeah,
candidate?
you could have something as simple as what the Division of Taxation uses. It's just a little statement it's almost a POA for that purpose. And it'd be fairly easy to put on.
I have a question. I mean, it's a good suggestion because you had people show up who want to speak on behalf of a candidate, but the candidate's not here. And our rule was only a lawyer can speak on behalf of the candidate. So Ray, I know I don't want to put you on the spot. So how do you reconcile this?
No, I think what you're speaking to, Mr. Scholes, is a hearing before a quasi judicial body. The only people who can appear on behalf of another in any agency court is a licensed attorney. So we have rules on that. I think what Rob is speaking more to is like under 17, 14, 11, there's a need to make an immediate objection to the signature. And the local boards are required to make a ruling on the spot, essentially. In those cases, that's not like a quasi judicial tribunal. That's an agency function, and it would be appropriate to have a representative. In fact, if you're running for a statewide office, and you may be, I mean, optimally, ideally, having people in 39 cities and towns during that process, you couldn't, the candidate could not be there in every location. So having a representative would make sense. But that's not like a hearing before us.
Yeah, well, it's well noted. I agree with that position. But I thought the impression was, I got the impression that it designates somebody to appear before the board. But Rob, you-
To file
Yeah.
a challenge.
File a
Okay, all right.
challenge, right, to make a challenge to the signature, yeah.
Thank you. Mr. Lima.
Thank you. Good afternoon, members of the board, Madam Chair. Miguel said this to the Elections Committee. I saw a couple of responses, but the Elections Committee as a whole hasn't taken a position. Neither has the Cranston Board of Canvassers, although I did speak with our staff and our board chair about the proposed regulation. The perfectly fine with everything in the regulation, with the one exception being the driver's license issue. And there's two reasons that our office has concerns about that. The first is because of the huge amount of public interest in nomination papers. Just in our office, we'll have anywhere from 40 or 50 Title 17 candidates come in and declare in June that go out and get nomination papers. And for any one of those candidates, we could have 3 or 4 or 5 different individuals and parties request copies of all of the papers for that particular candidate. That's routine. It's not uncommon for us to issue hundreds, if not thousands of copies in one election cycle of nomination papers. That's front and back. As you know, they're legal size. It's not the easiest thing to copy, particularly when we're copying original forms that have been circulating and have tears. Of course, it's jams and machines. So a lot of times we ask the candidates or the representatives or whoever's asking copies at our front counter, say, hey, listen, we can charge you the 15 cents per page, which is the maximum allowed charge for these copies. Or if you want, you can actually just take a picture of them if that suits your purposes. And the vast majority of people take us up on that offer and just take a photo with their phone. If they want copies, we obviously have to provide them, and we do. But that saves us a lot of time. It saves them a lot of time because, like I said, for one particular campaign, you might have 20 or 30 papers just for one local candidate. And they'll stand there at our counter and take pictures of all the forms, and then they have them. And they're on their way. If personal identifying information like a driver's license number was included on the forms, that would make those forms confidential records. That would preclude us from even showing the original forms to any interested party that came to our office. So that would certainly add a burden for us because, as Rob mentioned, we would have to go through form by form, which could be hundreds of forms, and redact every single one. And since these are originals, the only way we could redact them would be to scan them in, which I already mentioned the difficulty we can have in even copying them, so never mind scanning them, and then go into a PDF editor and actually remove that license number and then provide copies. Now, I know for a fact that most campaigns and candidates who are accustomed to seeing the original forms will not be too pleased if we provided photocopies with the redacted version. So that's the first concern. It's more operational. But the other concern is the local board is required to meet, review these forms, although the staff is functionally going through the signatures, but the board itself, the local canvassing authority, has to certify each paper individually with at least 2 signatures for a quorum of the board. That has to be done in public view. There's obviously a public interest in that process, and it's done at a public meeting. Typically, if the board is going to be reviewing any documents at a public meeting, that's generally going to be a public document. The board wouldn't, if there's something that was confidential or that we would be hesitant to give out publicly, it would not be presented in a form in which any member of the public in present and attending the meeting could look over a board member's shoulder and see something that was confidential. So the issue for that would be, for us, would be if a license number was on the forms, the original forms, which the board does have to sign, we could only do so under executive session. But there's no current provision in the Open Meetings Act that allows local boards to meet in executive session for that purpose. So we'd be presented with a flawed choice to either have the board review them in executive session and violate the OMA, or potentially violate the confidentiality of those license numbers for multiple people. So that's the other concern, which is I think more of a legal concern on our end. It's been mentioned maybe having a supplemental form. There could be some process issues there. My suggestion would be to, in lieu of a driver's license number, since the real interest in capturing that would be just to identify the person, right? Perhaps just to have the date of birth of the circulator. The date of birth is not a confidential piece of data. If someone requested a voter registration form from our office, we would have to redact the driver's license number. We'd have to redact the social security number. But the date of birth is not something that's required to be redacted under the current law. So that could suffice. And I know I can't speak for law enforcement agencies, but if the main purpose is to help law enforcement identify in those instances of fraud, having the name, address, date of birth of someone would be helpful. Now, it should also be noted that the affidavit that circulator has to file must be signed in the presence of a notary. And it is incumbent upon a notary, it's their sworn duty, in fact, to be able to identify the person who was signing the affidavit for them. Now, they must either be personally known to that person, or that person must provide to the notary a driver's license, passport, some sort of photo ID to prove who they say they are. So there is already a protection built in there. Now, notaries may or may not keep a log of who they've notarized. Yeah, it's a good practice for notaries to do so. I know not all do, but that log may actually capture that driver's license number, and that log could, in cases, be subpoenaed by the Board of Elections, the Board of Canvassers, or any entity conducting an investigation that has that authority to do so. But that said, I think that the problems that having the driver's license number on the form could cause are probably more pain than help for the process.
Thank you. Any questions left for Rob or Nick?
Are you putting this in writing, or are you waiting also for more feedback from your staff and team?
I can certainly submit a comment in writing to
That
the
would be
board
great.
to that effect.
you.
Absolutely.
Miguel?
So I think regardless of what the board decides, at the very least, we need to have more information on this form that currently is at the bottom, because
Yep.
just asking for the signature residence address in the city and town and state has not been helpful or adequate when looking into these cases. Now, regarding the driver's license number, I mean, I will say that there is precedence to that, because in 2020, during the pandemic, through an executive order, the board, which the board supported, required that mail ballot voters, 125,000 mail ballot voters actually, had to include their driver's license or their last four digits of their social security number on a mail ballot certification envelope, which the board did review in public. However, we did have to redact those driver's license numbers before having it in a public hearing. So in terms from the staff's perspective, part of where this came from is because there is precedent in when we required that of those 125,000 voters by mail, when the notary requirement was waived by executive order in 2020. However, that being said, I think that we do have to have more information on that form, whether it be the email address, the phone number, so that it is clearly printed. I think the concerns that we had over the last two election cycle weren't so much with the person not being who they were when they were before the notary. We didn't have any allegations of folks not being notaries fraudulently notarizing something. It was more the case of they were who they were when they went to the notary. However, what they collected was deemed to be questionable. So I think our focus from the staff's perspective, just looking back on our experience in 2022 and 2023, is to make as clear as possible to these individuals submitting these nomination papers forms that if there is an issue or a question regarding the signatures that they collected, we are going to have adequate information to track them down and provide that information to law enforcement to conduct an investigation.
Thanks, Miguel. Anything else?
So at this point, I think we would just continue to receive, we've taken these comments already from Nick and from the Secretary of State's office, and I'm sure we will receive additional, both in writing and by email. So we'll just present those to the board at the next board meeting, which is on June 4th.
Okay. Thanks, everyone. Does the board wish to make a motion?
Do we make a motion? I don't think we have to make. a
Are we
motion.
do we have to commence no?
No.
It says
So you will-
discuss and vote to
I
modify.
think you
the
should
rules
take
and-
a vote, and you should note that since it is unusual that we're going to have a slightly truncated public period of until June 4, that's when the public period would, do you want it June 3 or June 4?
I would say June 3 to give us time to produce anything that's provided before, just the day before the board meeting.
So
that would
you
be-
want a motion to close
that would be-
public comment?
At that time, that you would, yes, so that to start it and to, as of today, and to close it. As of
I'll
the
make a
third.
motion to include today as the commencement of public comment on this particular regulation, and to close public comment on this particular regulation on June 3.
Can I just,
The close of business on June 3.
sorry, Commissioner, can I ask a question that hopefully won't throw a wrench? with ample time right now and posting, can we change the meeting so that there's like, change it now so that we can allow for the full 30 days?
I would say that based on past experience with rules and regulations, the meeting is actually the day of the Cranston special election,
Okay.
which is why we're holding it that day. We can certainly hold a meeting at any time other than that, but it would require the board to come back in, and then we
It'd
would
be an
need to come
additional-
back in again for the purpose of finalizing and promulgating the regulation. And I
Okay.
believe there is a 20-day period before the objection period begins that has to happen for this regulation to actually go into effect, even though it's not subject to the APA. But I could be wrong on that. But I think as much time as we can allow before the nomination period,
Yeah.
the better.
Yeah.
Mhm.
Okay.
I'll
That's
second that
fine.
motion.
Okay.
I'll second that motion.
Motion and seconded. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye. Any opposed? The ayes have it, and we will commence the comment period. And the last item on the agenda, the board may hear and consider any election matter that requires an immediate ruling or determination arising from the South Kingstown special referendum and the Charahoe Regional School District special referendum elections pursuant to Title 17 of the Rhode Island General Laws. Yeah.
Members of the board, I'm pleased to report that I have no issues to report to you regarding today's special election that would require an immediate ruling or determination. However, very briefly, I will just give you a summary of the special election and that conduct today. As of 1:15 this afternoon, a few hours ago, approximately 880 of the 20,791 eligible voters in Charlestown, Richmond, and Hopkinton had voted for an approximate turnout of just over 13%, which is probably slightly higher now at this point, a few hours later. 1,778 voters voted during the early voting period, which ended at 4 p.m. yesterday. In South Kingstown, turnout is very brisk. 5,606 of the 21,800 registered voters have voted for a turnout of about 26% as of a few hours ago, which that has probably gone up a few as well. 4,186 voters voted during the 20-day early voting period. So they had a very early voting period. In fact, we had to issue them additional ballots because the Secretary of State issued additional ballots because voting exceeded what the expected turnout would be. So it's been very busy. The Board of Elections has 2 technicians deployed today to the 7 polling places in operation across the 4 cities and towns today. We have had no equipment issues or any other issues to report at the polls. We have received 199 of the 271 mail ballots requested by voters. We still have 72 ballots still outstanding for both special elections. We will start tabulation of those mail ballots this afternoon. We expect to be receiving results from the polling place and early voting sites shortly after 8 p.m. tonight. The results will be available for viewing on our website, which is new, as we typically have not published on our website in a format as we publish for our statewide special elections. But this will be the first official time that we actually publish in a format similar to what you've seen in the presidential preference primary and the general elections. Typically, we've posted up a PDF, but this time we're getting a little bit more sophisticated in how we publish our results. This concludes my Election Day report on Charahoe South in the South Kingstown special elections, and I am happy to answer any questions from the board.
Thank you, Director. Any questions for Miguel?
No, Madam Chair, I would just commend the director and the staff for putting that on in that format, because I know how important it is to the local communities, and I know they'll appreciate getting that,
Yeah.
being able to get that information just as if it were a statewide election. So, thank you.
Thank
Agreed.
you.
Okay, do we have a motion to adjourn?
So moved.
Second.
Moved and seconded, all in favor signify by saying aye.
Aye.
Aye. And we are adjourned at 4:45 PM. Thanks, everyone.